Good morning, everyone. Welcome to the 200th District Court. We are here in cause number Perez versus Archer Western. And before we proceed, let me just get y'all to go through introductions.
Good morning, Your Honor. Burgess Williams on behalf of the plaintiffs.
Ryan Toomey on behalf of the plaintiffs.
And Shelby White on behalf of the plaintiffs, Your Honor.
Good morning, Your Honor. This is Brett Sanders on behalf of defendants Archer Western Construction and Martin Tirado Mendoza. I have with me here today Laura Segal.
Okay, Segal. I was wondering. All right, I'll try to remember that. All right, folks. I think you found out yesterday that you have been reassigned. We have you coming in Monday morning to complete whatever pretrial we don't finish today, and the voir dire panel Monday afternoon at 1. Are y'all all on the same page with the court?
Yes, Your Honor.
Yes, Your Honor.
Yes,
Okay.
Judge.
And I think you will probably get the voir dire list from the clerk maybe this morning, sometime today. So please be mindful of the clerk's deadline. If somebody wants a shuffle, ask for it by the time indicated, because if you don't, you may not get it. All right. What I would like to do is start with the limines and then talk to you a little bit about witness, exhibits, some of the other motions and logistics. Anything that needs to be discussed before that, let me know. I guess I'll inquire with Mr. Williams first.
Thank you, Your Honor. Quick question for the court, because we were anticipating that we were going to start this Monday, and it changed, and we're ready to go. But just for expectations today, how long do you anticipate spending with us today, just so that we can shuffle things around if need be the rest of the afternoon?
Only an hour and a half.
Okay.
I only have till 10:30, and then I have to leave for some meetings.
Understood.
So
That clarifies it.
yeah, this was kind of the best we could do under the late breaking circumstances.
Understood.
Okay. All right. And so whatever my goal is, certainly I'd like to get through the limines, talk to you about your witnesses, your exhibits, timing. Maybe, we're not going to have time to go through your deposition designation. Maybe we'll get to your kind of motions on that topic. Maybe we won't. But I don't anticipate we will get that big pile of whatever you want to call it, work that you have put in front of the court. I don't anticipate getting through that today. I do want to go through kind of what I call housekeeping items. I want you to know how I run my courtroom, what kind of schedule I keep, and what kind of time limits I'm likely to give. So hopefully we will talk about all those things before 10:30, and then I assume y'all may still need to confer on some issues. Is that correct?
Yes, Your Honor.
Judge.
Okay. Well, then hopefully what we do here will guide those discussions to some degree. Yeah. So my understanding from the docket call was that your time announcement was 5 to 7 days, which is kind of is that still what we're thinking?
But Your Honor, we officially announced for 7. Obviously, we would love to give the court some time back, but I think that's going to be dependent on some variables that have yet to be defined. So we would endeavor to get our case done as quickly as possible. But there's some things that I think we need your help on, Your Honor, to decide in order to give you a firm commitment on time from from the plaintiff's vantage point.
Okay. And Mr. Sanders?
Your Honor, if 7 days is the announcement from the plaintiff, then I think I can certainly get my case on and off in 3.5 days. Absolutely.
Okay. All right, fair enough. I presume that you will all know this, but I believe the voir dire will take most of Monday afternoon. That's my experience for a case like this, is that we would get the jurors in the box by 5 p.m., let them go, and openings would be Tuesday morning. And for a 7-day announcement, I'm probably going to seat at least one alternate. You can tell me if you think you need more than one. Do we think one is sufficient?
I think one would be fine, Your Honor. I don't know of any reason why we would need two. I know the last trial I had in Travis County, the court seated two. But Burgess, what are your thoughts?
Yeah, no, that would be fine by the plaintiff, Your Honor, and I assume that you would not have the alternate deliberate with the jury. That's always been my experience.
No, I think
Yeah.
I'm required to let them go unless there is, even if there is an agreement, I think the code says shall dismiss. So that's what I've been doing. Okay. All right. Then let's go ahead. Before we delve into motions and limine, let me just get on my soapbox for one quick second and tell you, and I'm not speaking necessarily about your limines, but in general, we have seen a trend of people filing limines that look like this. The other side's theory of the case is A, B, and C. Our theory of the case is XYZ. Therefore, judge, no evidence or questioning about ABC should come in or take place. And, let me just say, these types of limines are not effective or helpful for anyone. And the jury in this case and in any case is going to hear the disputed facts and they're going to make decisions based on them. And so that's just my soapbox speech on it. Hopefully y'all don't have anything that falls into that category, but I did have a cursory opportunity to review them. I'm hoping y'all are ready to at least tell me what limine items are agreed, and then we can hear brief arguments on the items that aren't.
And Your Honor, if we want to go through just at the court's, whatever the court wants, but I'm happy to go through plaintiffs first since plaintiff has the burden. So
yeah,
we want to start there.
Yeah, Mr. Williams, are you able to identify any of your limines that are agreed to?
Yes, Your Honor, and I'm gonna defer to my my co-counsel, Mr. Toomey, to take the lead on those.
Okay,
Yes, Your
Mr.
Honor.
Toomey, go ahead.
Thank you, Your Honor. And Mr. Sanders and I spoke about these yesterday afternoon, and so Brett, if I get one wrong, just let me know. But my understanding is the ones to which we agree are number 1, number 3, number 4, number 5, partially to number 9, number 11, 18, 19, and 23.
Okay, what was after 11? 19?
11, 18, 19, and 23. And Brett, if I got any of those wrong, please let me know.
Yeah, so I want to make sure that I have the correct copy of because we file an amended motion in limine. So let me just run through them real quick. So Judge, attorney specialization, which is item number 1, I'm agreed to that. That's fine as long as it's reciprocal. They're not talking about defense attorneys and how big our firm is, or the fact that we've got multiple offices or anything like that. Uh, Attorney-client privilege, I don't know exactly what they're referring to. I think what they're referring to, Judge, is text messages that the plaintiff had sent to right after this particular automobile accident to Burgess Williams. And actually, it wasn't even to Burgess Williams. So as long as we're not excluding text messages between Samantha Holliday, a witness, and a referral to Amanda Burgess, or Amanda Williams, which is Burgess's husband or wife, I should say, I'm fine with it because that's not attorney-client privilege. So number 3 would be okay with me. In terms of number 4, I don't know exactly what they're referring to. I told Ryan this yesterday, but witnesses not revealed in discovery. I mean, that should be fine. I don't plan on calling any witnesses that have not been previously identified at this time. So it would have to be a true surprise. Number 5 is surveillance, as long as that's reciprocal, films or tapes. The only videotapes we have are of Mia Garza, the minor, and he knows about those. So my understanding is that's not on the table for that. So we can agree to that if that's all they're referring to. Number 9, there is that needs modification. They're trying to limit what we can talk about in closing on that one. So there is no agreement on that one. That needs to be modified. In terms of number 11, as long as that's reciprocal, I'm agreed to that. We've got the same motion in our motion in limine. Number 15, I don't know if Ryan mentioned that. I'm fine with that. Number 16, I'm okay with that. They didn't want me talking about any of their previously filed pleadings, and questions about pleadings are those are legal matters anyway. So I'm fine with that. Number 18. It talks about witnesses who were not identified. I don't plan on calling any, so I'm fine with that. Number 19. I say I'm fine with 18. Let me just revisit that, Judge. I think we probably need to visit about there's some issues with late produced discovery, and I do think that there may be some comment in this case about some documents that were produced after the expert designation deadline. So I want to make sure. So leave that one off the table for now, please. Number 19. I think that falls in the same category, so I'm not quite sure of what specifically they're asking. So we need to talk about that. And then number 23. I don't have any issue with that as long as LOPs are not included with that. So that may need to be modified. And that's what I have, Judge.
Mr. Toomey, any comment on those items?
Your Honor, the only one out of what Mr. Sanders just discussed, number 3, he alluded to some text messages between one of our lay damage witnesses and Amanda Williams, who is Burgess Williams' wife. We believe that those, and we can take those up at a later time, but those are covered under the standing motion or standing order in limine, because they do deal with how plaintiff Ashley Perez got to Williams Caputo or Zinda Law Group at the time. And so that deals with the hiring of the attorney and how she found us. And so we believe that would be under the standing order in limine, but again, that's where that would fall. And so otherwise, we would be in agreement with Mr. Sanders.
And Your Honor, just to clarify, so we don't have a Will Smith moment here. The text messages were between a before and after witness and our client. Not my wife was not involved. So just to clarify.
Okay. All right. Well, it sounds like we can. Are those text messages a possible exhibit? So we can talk about that later.
We could, Your Honor, and the only reason that we're responding right now is that Mr. Sanders believes that those come in and that they would be relevant to this motion in limine. But the reason why we did not actually put that specific motion in limine in ours is because it is part of the court's standing order on motions in limine. So based on plaintiff's understanding of how that standing in limine order reads, those would not be admissible or couldn't be referenced.
Okay. I'm glad you mentioned the standing limine, because I know Mr. Sanders just mentioned 18 and 19, and honestly, I think the standing order in limine may cover, those items. So I want to be sure y'all all review and revisit the standing order and limine and know what's out based on that. But we're just going through agreements for now. So I think we got the agreements on the record. And I'm ready to go ahead and go through the contested items, which I think would be 2.
Yes, Your Honor. And so for plaintiff's motion in limine number 2, we just want to make sure that there's nothing, essentially that there's no surprise, and that anything that's not proved up under the rules, anything that would constitute hearsay, that at least the court grant an in limine on, because I think this just mostly tracks what's in the hearsay rules. Specifically.
All right, Mr. Sanders.
Well, Judge, I'm not sure what they're referring to. They're not citing any specific evidence, and that they're trying to keep out. So a blanket order about the rules of evidence, they dictate that there are certain exceptions to hearsay, and then dictate what come in and what's admissible and what's not. So, for example, I don't know if they're talking about the crash report where it lists a citation, which would fall under potentially 609. It would also contain information like financial responsibility, which is insurance, which is not admissible. So I don't know what they're talking about. That's the problem that I have with their number 2.
All right, Mr. Toomey, I guess, are you able to identify what, if anything, this applies to? Or
yeah, so yes, Your Honor, and we're not referring to anything specifically. I believe, unless it changed in defendant's filings last night, we both listed the crash report in our exhibit list. We both listed defendant's internal investigation report in our exhibit lists, things like that. But any other items to which we are not able to agree, that would constitute hearsay, such as text messages and things like that, we would want where we would say would fall under there. Obviously, with the crash report and other documents like medical records and things like that, there have to be redactions made for insurance, for other hearsay like the citation, and things like that. And so we're not disputing Mr. Sanders on that. It's just anything that would constitute hearsay, where there's not a proper predicate laid or not an exception for that hearsay. For example, the text messages to which we alluded to earlier, we believe those would be covered under the motion to limit.
All right, well, I'm going to grant 2 for now. Again, it's a limine, so approach the bench. That's all this is doing. All right, number 6.
So number 6, Your Honor, this specifically deals with medical expenses. And just to give Your Honor a brief procedural history in this case, plaintiffs designated a billing expert, I believe originally about a year ago, and then again in December at our most recent expert designation deadline, filed affidavits and the like. Defendants filed counter affidavits and then designated a billing expert as well. But that billing expert was struck by order of the court a few weeks ago, if not a month ago. And so it's our position that those numbers are no longer in dispute because their witness was struck. And so they don't have any evidence to dispute what's contained in the affidavits, and more specifically to what our expert is testifying. Mr. Sanders indicated when we were discussing this yesterday that he wanted to make an offer of proof for Mr. Bretches, and we understand that, but that would be outside the presence of the jury. And so an offer of proof wouldn't fall under this in limine because the jury wouldn't be present when that offer is being made anyway.
Okay, Mr. Sanders.
Your Honor, yes, I am going to be making an offer of proof. Mr. Toomey is right on Mr. Bretches because I don't think that the ruling complies or it falls in line with In re Allstate. But intelligent minds can differ on that issue. But that's not the only reason. The other reason is that we've got a doctor who says that this surgery is not necessary. So to the extent that they're trying to limine out our surgeon and his opinions that this surgery is which hasn't been performed yet, which is just a recommendation. It's a 4-level ACDF fusion, is not necessary. I want to make sure that we're not getting sideways with that in this limine. So I can't agree to that.
Okay, and the surgeon was not struck. Only the billing
Correct.
affidavit person. Okay,
Right.
well, Mr. Toomey, tell me what's your response to that?
Yes, Your Honor. Number 6 only apply. We're only talking about past meds in number 6, and so future recommendations would fall under wouldn't fall under this. And Mr. Sanders actually has an in limine item about certain future recommendations, and we understand that's being disputed. But specifically with regard to these medical expenses, it talks about healthcare services that were already provided and affidavits for those healthcare services, as well as, like I stated earlier, our experts' testimony. And so we don't believe that this would apply to that. It's just the past as of right now.
Okay, so Mr. Sanders, surgeon, gets to testify, and 6 doesn't prevent them from doing it. It's past medical care in 6.
And Your Honor, if I may, it's the bills. It's not the necessity of the care. That's what we're talking about here. Mr. Sanders designated Dr. Simmons to give opinions on whether the care was necessary, both in the past and future. And we're not disputing that he gets to talk about that. We're simply talking about bills that have been incurred in the past.
Okay, all right. 6 is granted. That'll take us to 7. Isn't this one covered by the standing limine?
Your Honor, I didn't see it in the standing in limine, but
Okay.
part of the reason why we added this one and kept it on here is the defendant's jury charge actually discusses taxation, and specifically has an instruction about taxation, in references the PJC, but as Your Honor is aware, in the section of the PJC 28.2, where it's discussing income tax and the taxability of recovery, it's only supposed to be submitted when there is submission of loss of earnings, loss of earning capacity, loss of contributions, or loss of inheritance, which none of those are being offered in this case. And so none of the remaining items under plaintiff's pleadings would be subject to taxation. And as a result, there wouldn't be the confusion or the need for the instruction.
Judge, just to clarify, I don't plan on bringing this up during during the trial. We pulled this straight from the PJC and it was included in our jury charge. So okay, we didn't lose. I thought we lost you for a second.
No, I'm here.
So it's in the PJC. That's where we pulled that from. But I do not intend to talk about, hey, she's not going to be taxed on any money that you award. That's not going to be my presentation or my argument.
Okay. Well, then I think I'll go ahead and grant number 7. Number 8.
Yes, Your Honor. And so this is something, let me pull up my notes, because so this is something that we want to make sure that this isn't the place for argument. You know, obviously, Your Honor, this is something that the parties may want to discuss in voir dire. I'm sure the defendant is going to want to talk about tort reform as well, and the plaintiff is going to want to talk about verdicts and things like that, and get jurors to share their opinions on personal injury lawsuits and things like that. But we're just wanting to make sure that specific argument about, you know, we all pay, we all lose, everyone loses no matter who wins this case, things like that are kept out.
Mr. Sanders?
Thank you, Judge. They are specifically referencing insurance premiums or effect of a judgment may have on insurance premiums. I'm not going to be injecting insurance into this case. You know, in terms of voir dire, typically there are questions that are asked on the plaintiff side about jury verdicts and whether or not the verdicts, if people think they're excessive because they try to kick certain jurors off. I'm not a fan of that, but I think they're filing this motion in limine and they're limiting themselves because I think that they're going to be asking those questions in voir dire. So I don't anticipate making any comments about we all pay, we all lose, or anything that Mr. Toomey just mentioned, but I'm not quite sure that that's all that this is encompassing. So I don't intend to say those things, so I don't think it's going to be an issue, but I don't know what other inflammatory slogans they think I might utter in closing. So.
All right. Well, I would presume in closing, everyone's going to be focusing on the evidence and what they want the jury to do with it, and not talking about tort reform or excessive verdicts or, I don't know, but seems like there would be room for y'all to agree that you might voir dire on some things, but that the actual panel of jurors is not going to be hearing such arguments about tort reform.
Yes, Your Honor.
Yes, Your Honor.
Okay. Are we on the same page as far as what we can do in voir dire and what is not appropriate during the trial itself?
I believe so, Your Honor. And that's why I made the statement when I was presenting our side is we understand. I'm sure we'll ask about verdicts. I'm sure the defense may ask about verdicts, things like that. But I was talking more about argument and asking those questions during examination or anything like that.
Okay. I'm going to make a note that this is modified, and I believe during voir dire, counsel may generally inquire of the panel about things that aren't insurance, verdicts and awards, but that once we're in the trial itself, if anybody wants to get into this territory, you will approach the bench before doing so. All right?
Yes, Your Honor.
Sure.
And then I think 9,
9 is very similar, I believe.
yes. Let's see. Could we have the same understanding that voir dire is a little bit different as far as your ability to inquire of the panel versus what we're going to do in the trial itself?
Yes, Your Honor.
Can agree to that, Judge.
Okay, I'm going to mark that then as modified by our discussions here. 19 experts.
Did you mean 10, Your Honor?
Oh, I'm sorry. It is 10. Sorry.
I just wanted to make sure I didn't need to jump ahead.
My contact lenses are a little blurry this morning. So yes, it is a 0 there, isn't it? Go ahead.
That's okay, Your Honor. I don't get to see for free either, so I understand that. This is mainly talking about opinion evidence offered by persons who aren't experts, and we specifically discussed the police officer. And I think Mr. Sanders was in agreement. Obviously the police officer can talk about his observations, his discussions with the parties, photographs that were taken, things like that. But specific opinions is something that we're discussing, whether it be with the police officer or any other witness who's not an expert in this case.
That's the document.
And obviously it's up to the court's discretion if the court believes that the police officer or another person is qualified as an expert witness, then that person can testify in kind. But aside from that.
Okay, well, typically police officers are fact witnesses unless they have the reconstruction training and did an actual reconstruction, then they're not typically permitted to offer expert opinions. I guess I'll hear from Mr. Sanders on this one.
Thank you, Judge. As you know, and I had this conversation with Ryan yesterday, police officers are first responders, and they're trained to go to a scene not only to assess the situation, but determine whether or not medical care is appropriate. And they do fill out police reports, and they do make notations as to whether or not people that are involved in accidents are injured to the extent that they need an ambulance, EMS, whether they need to be transported to the hospital, whether they need some care, whether they want that. And in addition, so they do make observations as to general health conditions. And they even note it on a police report. I haven't made up my mind whether or not I'm going to whether we're going to have an agreement as to admission of the police report or whether or not we're going to have to rely upon the court's ruling after certain redactions are made. But I do want to make sure that I'm going to be able to ask the police officer questions about the medical condition and the assessment. And then in addition, there are about 5 friend witnesses or support witnesses that plaintiff is going to be calling. And I want to make sure that I'm not limited in any way, shape, or form in terms of asking questions of those witnesses in terms of injuries. And that's what this seems to be is, we don't want you talking to anybody about your observations unless they are they're an expert, and I can't agree to that.
All right, Mr. Toomey.
Yeah. Oh, sorry, Your Honor.
Go ahead. I think the officer, what he did, what he saw, to some degree what he thought, but he's not gonna tell the jury, you know, causation of the accident. He could say, was it a rear ender? Was it, you know, what he thought based on what he did? But I think most of their opinions would be lay opinions, but whether he thought an ambulance needed to be called or not seems to be fair game, I would think. So what are we after here?
Yeah, and I think, Your Honor, you hit it on the head. We're not trying to hamstring anyone talking about their observations, not the police officer, not our own lay damage witnesses that we're going to present. If they observe something, if they, formed an independent belief because of that, then of course, that's fair game. But whether, like you said, anything about who caused the crash or causation about injuries or anything like that, I think that's what this covers.
Just reading back over the language. All right, I think I'm going to grant it as it's drafted. So again, this is merely an approach the bench type situation. I think 95% of what y'all are going to talk to the officer about probably are facts and not opinions, and certainly not expert opinions. But if you get to that area, let's have a discussion. Is he going to be a live witness?
Yes, I've got him under subpoena, Judge.
Okay. Fair enough. So, but I don't anticipate anybody's going to proffer him as a accident reconstruction expert, because I presume he's not, those aren't done unless it's a fatality typically. So,
Yes.
all right.
And we have our own accident reconstructionist too, so we wouldn't want
Okay. Great. All right. 12.
12, hopefully this one, and we can make some of these shorter for you, Your Honor. 12 is just referencing vacations because of the inflammatory effect that would come along with talking about somebody going on vacation while they're suffering from an injury. Obviously, people can do things while they're hurting, but saying that plaintiff was just spent so much time at a vacation or traveled or anything like that may lead the jury to have some unfair prejudice because of the nature of a vacation versus not. So that's all our limine is intended to target.
Response, Judge?
Yeah, briefly.
Yeah, thank you. So we do intend to talk about and bring up the fact that plaintiff was able to travel. She has a daughter that was involved in this accident. And just to give just so the court is aware, it's less than a 20-mile-an-hour rear end accident that happened on 71 on the way to the airport. But she did travel to Oklahoma. She did travel for gymnastics. She did travel to, in terms of fly to Kentucky to go see for a medical appointment. She did go other places. So we do intend to talk about that. So I'm not quite sure what they mean by vacation, but we do intend to talk about those things. So I can't agree to that.
Right, Mr. Toomey, this one's denied.
Okay.
This falls under what I would call fair game, how people have lived their life since the accident. That's exactly what the jury will hear and needs to hear about. So 13.
Yes, Your Honor, this is just talking about mitigating damages. And since this is an affirmative defense, it's our belief and understanding defendant has the right to, or the responsibility of proving that and proving that the failure to mitigate caused further damages. And so we just want to make sure that everyone is tied to the proper burden. Specifically, if plaintiff incurred medical expenses that didn't get submitted to a health insurance carrier or anything like that. We want to make sure that that doesn't go in, because a lot of times defendants argue that that's a failure to mitigate on its own based on the insurance contracts and agreements.
Mr. Sanders?
Thank you, Judge. In this particular case, Your Honor, there's Dr. Vasudevan recommended physical therapy, and there's going to be evidence that she didn't comply, that Ms. Perez didn't comply with that. So that's going to be evidence that we're going to be introducing or plan on introducing to the jury, and that they need to hear. And so in terms of, other failure to mitigate, I do not anticipate bringing up insurance. That's something I would like to keep out in front of the jury. But I do intend on introducing evidence on failure to mitigate, so I can't agree to that.
All right. Mr. Toomey, anything else on this one?
Not anything in addition to what I already said.
Okay.
Yeah.
All right. I'll deny 13. 14.
Your Honor, 14 thought is pretty simple. Anything that's not pled in the pleadings, claims, counterclaims, affirmative defenses, anything that would constitute surprise, because we're well past the pleading deadline, even under the rules, let alone our own scheduling order. So,
Your Honor, I don't know what the evidence is going to reveal in this case. I don't plan on bringing up anything that's outside of the pleadings, but the parties have, previously testified, and I don't know what Mr. Williams is going to, or Mr. Toomey is going to be getting into. And so I can't agree to that, because as the court knows that, at the end of the case, attorneys frequently ask for jury instructions to conform to the evidence, and I've been involved in enough of these to know that. But I will say this: I don't intentionally intend to bring up some sort of new issue in this particular case.
Okay. So, Mr. Toomey, the problem for me is that I think it's just too broad.
understood.
For me, being the keeper of the limine, I need to understand what I'm doing and what I'm not doing.
Understood.
And I'm not sure that I can keep track of this one. So I'm going to mark it as denied.
Yes, sir.
17.
Really similar, but a little bit differently. The plaintiff in this case didn't plead lost wages or loss of earning capacity. She owns her own business, and going about proving that we believed would be difficult. And so I'm sure we're going to talk about, and the defense is going to want to talk about, plaintiff's work and ability to work. But the mere fact that she's not claiming lost wages or loss of earning capacity, we believe should be limited out in this case.
Okay, Mr. Sanders.
Yes, Your Honor. So I do plan on bringing up the fact that she's been working since the accident and has the ability to work. I don't plan on highlighting the fact that they're not asserting a claim, because I don't think that that's for lost wages or lost earning capacity. But I do need the opportunity to be able to comment on the fact that she hasn't lost work, and that is fair game. So that's why I want to make sure that I'm able to discuss those things at trial.
Your Honor, if I may, we'll withdraw 17.
Okay, sounds good. I'll mark that down as withdrawn. And let's see. Like I said, I believe that 18 and 19 may be covered by the standing order in limine. So I know y'all are conferring this afternoon in all likelihood, or after the Zoom. So I'm gonna let y'all compare those two with the standing order and see if that doesn't resolve it.
And Your Honor, apologies if we're overlapping. We thought we covered with a lot of red ink the things that mirrored the standing order on limiting items, but we'll take a much closer look.
Okay, and yes, fair enough. I don't have my standing order. I'm not side by side comparing it at this moment, but it feels very familiar and similar, so that's why I bring that up. If you find I'm wrong and we need to talk about it on Monday, bring it back to my attention.
Yes, Your Honor.
Okay, I think 20 is next.
Yes, Your Honor. I think 20 is pretty apparent and pretty it hits the nail if a particular expert is testifying beyond their areas of expertise, then I think that's, that should be at least a limiting point so that we can approach and discuss that with you and explain what we do and don't believe. I know Mr. Sanders made a comment yesterday that they believe one of our experts testified out of his areas of expertise, but that was handled and ruled on previously. They filed a motion to strike and a motion to limit on that point. And so we don't believe that that's in contention, but anything else where one of their experts may be attempting to testify outside of their area of expertise, whether it be neurologist talking about psychology or something like that, we should be at least a limiting point, Your Honor.
All right, Mr. Sanders.
Yes, Judge, thank you. My response to that is yes, their life care planner, we do believe, testified outside of his area of expertise. And we do have some objections to that. Those have previously been filed and they have been ruled upon. I don't anticipate offering any opinions outside of our designated experts' area of expertise. However, I do not want to be precluded from making an offer of proof because in this particular case, we have a discovery issue that we previously brought before Judge Cantu Hexel. We've argued. My motion to exclude that evidence has been denied. It impacts every single witness in this case. So I am probably going to have to, well, I won't say every single witness. I don't want to make that broad of a statement, but it impacts several witnesses in this case. And I'm going to have to be bringing these issues to the attention of the court before these witnesses testify. So there's going to be a lot of interruptions just regarding mental health records and the mental anguish claims in this case.
Okay, so the limine is just for the jury, and I think what you're talking about is probably presenting an offer of proof to the court about what would have been said or could have been elicited if the rulings from other judges might have been different. So the way 20 reads is your experts don't give opinions outside their designation or their area of expertise. Based on the plain language of that, I'm going to grant it. And then, again, it's an approach the bench and talk to me about it if you think there is something that you need to get into. But I think most of what you're telling me are going to be outside the presence of the jury, offers of proof about certain things. So anyway, 20.
Judge, if I can just real quickly respond to that and just get clarification. I know that the court is thinking of granting that, and I don't have, I mean, the court's going to grant or deny based upon what the court hears. But in this particular case, we have experts that did not have an opportunity to review mental health records because they were produced after our expert designation deadline. And we had been asking for those records for over a year. And the problem with that is that at this late juncture, I don't know whether when it comes time for trial in this particular case, whether Your Honor is going to allow me to, because the plaintiff is alleging a traumatic brain injury and she's been alleging headaches in this particular case, and there are other causes for those headaches apart and aside from a motor vehicle accident in this particular case. So that's the real issue that I have with number 20 is, is Your Honor going to be allowing me to be asking questions of my neurologist when it directly impacts things like headaches, these mental health and mental anguish claims, goes directly to those claims, Judge.
Okay. The plain language of this is beyond being within the area of the expert's expertise. So I assume a neurologist would be able to testify about headaches and related issues. So we can talk more about it on Monday, but yeah, we can talk more about it. But I don't think that the way 20 is worded, you don't get to have your neurologist come in and testify about economic issues because that's beyond their designation. That's the way it's worded. If late evidence is coming in your opinion, it's late. That's not I didn't hear that. But if there are things that you would have liked to have had earlier, but now you have later, and they're in evidence, I don't see why an expert who has that subject matter expertise wouldn't be able to comment on them one way or the other. That's not in front of me right now, but that's my thought. Okay. All right. 21.
Your Honor, we're going to go ahead and withdraw 21.
Okay. 21's withdrawn. 22.
Yes, Your Honor. I think this is the last one under our limine that is still in contention. Specifically, defendants have designated a responsible third party. That responsible third party designation was struck pursuant to the rules and the evidence of this case previously, and then defendants filed a motion to reconsider that after the testimony of our crash reconstructionist. Judge Gamble denied that motion for reconsideration. And so any argument that that it's the responsibility of someone who's not here, we believe would be misleading to the jury. It could also mess with a comparative question on the jury charge, because if the jury is attempting to or gets argument that someone else is responsible, then that comparative charge won't add up to 100%. Because that person isn't listed, and so we believe that any pointing the finger at anyone who's not a party to this case or remains designated, which now there aren't any, we believe would just be misleading and confusing to the jury and could lead to an improper verdict.
Mr. Sanders.
Thank you, Your Honor. The evidence is going to show in this particular case that there was a garbage hauler in front of Ashley Perez, and not directly in front, but in a different lane. And there was a 2x6 piece of plastic that flew out of the back of it that was unsecured. And so I understand Judge Gary Gamble's ruling, and I'll live with that. I am going to have to make an offer of proof on that because we did designate them as an RTP, and she struck the RTP despite the fact that plaintiff's expert admitted that it was a misdemeanor and admitted that this came out of the back and it was unsecured. But regardless, Your Honor, the plaintiff herself even admitted in her deposition as a factual matter that there was a piece of plastic that came out of this garbage hauler, and it's a roll-off container truck on Highway 71, which contributed to her stepping on her brakes to the extent where she literally stopped in the roadway on 71, and then and they need to hear that. The jury needs to hear that. So as long as I'm not precluded from talking about this piece of plastic or the garbage hauler or the facts surrounding this case, and I get to make my offer of proof on that, as long as the jury gets to hear, that information, then I'm okay. But to the extent that they want to eliminate 100% from the jury's ears that there was ever a garbage hauler in front of Miss Perez, or that a piece of plastic came out of it, or photographs from this particular garbage haul, this roll-off container truck, and the fact that it try to represent that it played zero role in this accident, I've got a problem with that, Judge.
Your Honor, if I may, we don't think that there should be zero mention of there being debris in the roadway. We're not taking that position. The reason why Judge Gary Gamble struck their RTP designation was the causal link. Yes, there was evidence that there was a crime committed. Yes, there was something that came out of the back of the truck, but everybody on the roadway but Mr. Sanders' client was able to safely respond to that hazard. So I think the jury has to hear the story, why people are stopping in Highway 71. We're not saying that Mr. Sanders doesn't get to mention that. What we're saying is that there should not be an argument that would lead the jury to be confused when it comes to the comparative fault question as to who was at fault, because that just creates a huge problem with Chapter 33 and the jury assessing comparative fault when they're arguing that somebody's at fault who's not on the line, and the court has already ruled that that person, that unknown party, can't be on the line.
All right. So I think I said this earlier and I'll say it again. Jury's going to hear the facts. If it's a fact that this happened, a piece of trash got in the roadway, people did or didn't react to it in a timely manner, the jury will hear about that. I do think argument about responsibility or fault have been precluded by a colleague's ruling on an RTP. Mr. Sanders, you'll be able to make your offer of proof on that issue outside the presence of the jury. So I think this is a kind of granted in part, denied in part. The facts are coming in, so evidence about what happened, that's all coming in. Argument about fault of someone that's been struck as a RTP, I'm not gonna allow that. I think it would be error. So, and you'll get to preserve your issue for a later day by the offer of proof. Okay.
Thank you, Judge.
Thank you,
Okay,
Honor.
that takes us through the plaintiff's limine. And then I think I received, defendant has a first amended limine. Is that the correct version, counsel?
Yes, Your Honor.
Okay.
And I need to. Not sure I have a copy of the first amended on my desk, but I'm able to talk about it. If they're misnumbered, I'm able to go through it. So.
Okay. Well, what I'd like to do first is hear from you the items that we have agreement on. And it's a little after 10, so I'd like to get as much done before we recess at 10:30. I don't know, Mr. Sanders, do you have the agreements or?
I do, Judge.
And
You
I
do?
wrote,
Go ahead.
Yes, I do. Item number 4, which is undisclosed or unrelated complaints. I believe plaintiff's counsel is agreeable to number 5. I believe that they're okay with, I think they're okay with number 8, number 9. I think they're okay with 11. I think they're okay with number 18. Number 21, which is court rulings. Number 22, which is damages aimed to help plaintiffs.
Your Honor, we actually don't agree to that one, and we can get to that.
22 is not agreed.
Correct, Your Honor.
We'll set it aside.
And number 32, which is references to Tirado using his cell phone, I believe they were okay with. And that's it.
Okay.
Your Honor, I would also add number 1 and number 2.
As agreed?
Yes, Your Honor. Number 1 is the motion in limine, which you already ruled on ours, and then number 2, the cost of defense, which is similar to 1 or 2 of ours that we made.
Okay. All right. So let's see. What I'd like to do is I'd like to pause now before we go through the rest of the limine, because I do want to give you those kind of how we run things in the courtroom and my expectations for Monday through the remainder of the trial. So we're going to pause for a moment, talk about those things for 5 or 10 minutes, and then pick this back up and get as far as we can. So with witnesses, are there any witnesses that someone plans on calling remotely?
No, Your Honor.
Well, Your Honor, I will add, there is a teacher that we have under subpoena who is employed under AISD. AISD was asking us if it would be possible for the witness to appear by Zoom. They have STAR testing going on next week. Our preference is to call her live because there's so many things that come with Zoom testimony that could be inconvenient for the court and the jury. So our preference is to call her live, and that's what we're intending to do. If something happens where the need would arise that we would need to call her by Zoom, we'd like to do so. We'd like to get agreement from the defense to do so as to minimize the disruption at the school. But that's where we are on that witness. That's the only one for us.
And
Is
for
that
the
the witness, I think her last name is TH, I'm not sure.
It's Tran.
Tran.
Yeah. She's the minor's current school teacher, Your Honor, and she's going to be a very brief witness.
Okay. All right. Well, I guess that's one more thing y'all can confer about this afternoon or after we're done here. As far as remote witness, how many witnesses are you actually putting on by deposition? Do we know?
We do. I don't have the exact number right now, Your Honor. I think it's in the 8 range, I want to say. I'm sure Mr. Timmy will correct me if I'm wrong.
And are those videos?
Sorry,
Video.
Your Honor.
Video
I believe it's
deposition, Your Honor.
11 videos, Your Honor.
11, excuse me.
You don't have any that you're planning on reading into the record?
No. I wouldn't want to inflict that pain on anybody, Your Honor.
Okay, fair enough. And I think I saw on someone's exhibit list that deposition transcripts were included. Those are not exhibits that will go back to the jury, so those would be court exhibits. And at the very end of the trial, what I am going to want from you will be a consolidated list of all admitted exhibits. The jury will get the exhibits electronically on a Chromebook that they will plug in and view on a screen in the jury room. It will be a lot easier for them to locate information if we provide them a running list of everything that is in there. So keep that in mind. I will be looking to you. It's obviously going to be at the end of the evidence. We'll take care of that.
Your Honor, can I ask a quick question of the court on
Yep.
that topic? Is the court have the expectation that we renumber the exhibits so that they're consecutively numbered from 1 to X, or can we have spacers that exhibits that are on the initial list but that didn't come into evidence or just kind of blank?
They are told at the end of the trial to not be concerned about the numbering or whether they're sequential or whether there are some that are they simply don't have.
Mhm.
So I am fine if, the list has gaps. In other words,
Right.
an exhibit was withdrawn or not admitted. You do not need to renumber that. I think that's not a good use of your time. And
Thank
I
you.
do give them an explanation that what they get is everything that's been properly admitted, and not to be concerned with the numbering or if there are redactions, etc.
Your Honor, if I can interject too, I think you touched on this a little bit. I wanted to be clear for the depositions that we are playing. Will the court reporter also be transcribing those at the time, or you want us to submit those cuts as a later court exhibit?
Depositions that are played to the jury have already been transcribed, and so we do not have the court reporter
Okay.
retranscribe something that's already been taken down. What you do is you highlight the played portions in a transcript and mark it court's exhibit 1, 2, 3, 4, 5. And those will be a part of the appellate record, but they do not go to the jury.
Mhm.
So yes, that's how we handle that. Okay. And then, so in looking at the exhibit list, I will just say, I hope that there is an opportunity for y'all to pare down. Y'all have got a lot there. So, I'll leave that to you. But, if you could come on Monday morning, having conferred about any exhibits that you can agree to pre-admit, we will take care of those. And then anything that's not agreed to be pre-admitted, you can just offer at the time, and if there's an objection, it'll be ruled on at that time. Okay. Okay, so I'm going to go over timing. I think we're going to start Monday at 9 with the remainder of your pretrial. We'll get as much done as we can and go until about noon or so. Voir dire will start at 1, and we'll pick 12 and an alternate. We'll get that done by 5 p.m. Then I'll let them go, and we'll start Tuesday at 9 a.m. We start at 9. We go till about 10:30. We have a mid-morning recess, 15 minutes. We'll go till noon. Then I will give the jurors an hour and a half till 1:30 for lunch. In any given day, I may need some of your time during that hour and a half. So, but the jurors will have an hour and a half recess. We'll go from 1:30 till around 3, maybe 3:10 or so. They get a 20-minute afternoon break. And then we reconvene, and we will go until 5. I do not keep jurors after 5. If you call a very fancy, expensive witness at 4:30 and you don't get them finished, you will have to bring them back the next day. They're away from their other obligations. So my job is to be very respectful of their time, and I intend to do that. So I think you were told about the bench bar conference on Friday.
Yes, Your Honor.
So, I will say I am one of the speakers, and I'm on the committee. And so I guess at this point in time, I'm kind of torn between, I would like to get your trial done and out of the way, but I would also like to attend. So at this point in time, I am thinking that we will give everyone the Friday off. If you have a big concern or an objection with me doing that, say so now or forever hold your peace.
We just want to know what the plan is, Your Honor, what you tell us, so that we can plan accordingly. Speaking for the plaintiffs, I won't speak for defense counsel.
Okay, Mr. Sanders.
Your Honor, I don't have an issue with that. It's, I completely understand that the bench part conference and your attendance is required at that if you're speaking. So I don't have an issue with that as long as the jury understands up front in voir dire and there are announcements made that this case is going to last, essentially go into the second week. That way there are realistic expectations and they know what they're in for.
Yes, I think that is my plan. If would be, yes, we always tell them this is a X number of day case. That means, the evidence will close by, in this case, we'll talk more, but whether that's going to be the following Monday, or the following Tuesday, somewhere in that range is what I'm currently mulling over. And you'll find out on Monday, I'm going to give you time limits based on when I think you can close your evidence. So anyway, so I think that's enough of the basics. I'd like to jump back to defendant's limine. I think going through that will give you enough information to have a meaningful conference about the remaining issues.
Your
And
Honor,
then, yeah, go ahead.
sorry to interrupt, Your Honor. Just for a point of clarity, are you able to tell us the amount of time that you're going to provide the parties for jury selection and opening today, or is that something we got to wait for Monday?
Oh, for your portion of the voir dire, you mean?
Yes, Your Honor.
Probably 30 minutes aside. Think that, that's pretty typical for what sometimes I give less, actually. But you can weigh in on that if you have a request, but keep in mind, I'm wanting to get it all done and get the 12 plus 1 impaneled by 5, which means that you have to be paying a lot of attention. At the end of the questioning, I will ask you, who do you want to strike for cause? And you will not have 20 minutes to think about it. You will need to have those numbers then and there. And then on a case that's going to go into a second week, we're going to get more people wanting to talk to us about medical and economic excuses. So I'm reluctant to, if I give you each 45 minutes, then we might be there after 5, which, would not be my preference. Let's put it that way.
Understood, Your Honor. Given the nature of the injuries and that there's multiple parties and kind of our current climate with respect to civil justice, we would ask for additional time beyond 30 minutes. I understand the confines of the court schedule, and I think that we could do it in 45 minutes and aside and get the jury selected before 5 o'clock. But obviously, I yield to the court.
All right, Mr. Sanders, what's your commentary on that?
Like an hour and a half if the court will give it to me. But,
I join in that, Your Honor.
Oh, wow.
But typically I would like an hour, but if the court's willing to give us, entertain us and give us 45 minutes, I would be very grateful.
All right, I'm going to make note of that request, and I'll let you know on Monday how that looks. If jurors are late, we don't start on time. There's a lot of factors to think about, but duly noted, and I will think about it. So I think back to the defendant's limine, I think we would be at number 3.
Yes, Your Honor. On respective wealth of the parties, there's been no punitive damages alleged in this particular case, and not to. The court doesn't know anything about this case right now, but plaintiff is going to be claiming that our client was in the course and scope. We're going to be saying just the opposite. I think that there's going to be multiple witnesses that I think are going to essentially waste this court's time after the court hears this evidence about whether or not this witness is in the course and scope. So what this respective wealth of parties is goes to limit the, how large my client, Archer Western, is, the number of vehicles or fleet vehicles it has on the roadway, the amount of money or income or revenue, that the number of employees, number of states it operates in, et cetera, because it's just not, it's not relevant, Judge, to this particular case at all. And I think it'll become clear to the court when the court hears the evidence and the jury hears the evidence.
All right.
Your Honor.
Yeah,
Yes.
go ahead.
Sorry, Your Honor. We believe this limine conflates wealth with things that are not directly tied to wealth. We're not going to talk about earnings and things like that because Mr. Sanders is right. We didn't plead gross negligence. We did plead direct negligence claims. We did plead that the defendant driver was in the course and scope. Mr. Sanders had the opportunity to file a motion for summary judgment on that. He did not. And so that evidence needs to be put before the court because at this point it's a fact question. Whether or not that gets acted upon later is for the court to decide, but we are permitted to put on evidence related to the direct negligence as well as the course and scope evidence. Discussing the size of the company and how many vehicles are on the road is different than discussing how much money the company makes each year. The amount of vehicles on the road, the fact that they are a registered federal motor carrier, which is also discussed in some of defendant's later motions in limine, that stuff is relevant because defendant Archer Western doesn't just have one or two vehicles on the road. It has multiple commercial vehicles as well as I believe the count is over 5,000 non-commercial vehicles on the roadway. And so those are substantial numbers, and it directly ties into the industry standards with related to fleets of vehicles as opposed to maybe one or two.
Judge, may I briefly respond to that?
Yes.
This is a program vehicle. In other words, it's a Ford F-150 that got involved in this accident. This is not a commercial hauler. It's not a tractor trailer. It's nothing like that. This is the same car that any one of us could go buy off the lot. And so that's what we're dealing with. And in order for the court to make an informed decision, the court needs to be aware that this is a situation where, and this is not a fact that's hidden. It's well known. My guy had left the project site and he was on his way home to go to a dental appointment. So that's what we're dealing with in this particular case, and we'll flush more into the facts at that point. But talking about the respective wealth of part, and he's right, Judge. Mr. Toomey is right. We could have filed a summary judgment, but for the fact that, there was a snafu that had to be fixed in a deposition, and I didn't have the confidence that I was going to get a straight ruling on that. So we'll deal with it at trial, which it needs to be dealt with at trial. But in terms of getting into net worth or revenues or the number of vehicles, that is a complete waste of the court's time, is a waste of the jury's time, and it's unnecessary.
Your Honor, could I just add this? And we're not going in. We don't even know what the revenue numbers of Mr. Sanders' corporate defendant is, but the number of vehicles in their fleet goes to foreseeability. We have a fleet expert who is going to be talking about what the industry standard is, what reasonably safe companies do, and we've got to be able to talk about that for this to make sense to the jury. And it's a component of one of the elements we have to prove, which is foreseeability.
Your Honor, if I may jump in.
All right. Let me just say, during trial, there's one lawyer per side, and we're not going to have this like tag team thing. Y'all are experienced and y'all kind of know better, but I've let it go on. But Go ahead. Everyone else has.
Well, the expert from who Mr. Williams is referring to will testify with regards to federal motor carrier safety standards, which do not apply to a Ford F-150 because the only requirement is to have a valid Texas driver's license in order to operate that vehicle. And so bringing up issues like the federal motor carrier safety guidelines, fleet, has nothing to do with this Ford F-150 and a valid Texas driver's license. Any one of us can drive that vehicle.
Okay. So number 3, as stated, this is gonna be granted in part and denied in part. So no testimony about net worth, revenues. I'm not sure at this point in time that I really see value in number of employees or number of states. This is an accident that happened here. That's what the jury needs to know about. However, you know, number of trucks or number of employees, those facts I think may be permitted. So I'm going to allow those, but exclude the others. Are we clear?
Yes, Your Honor.
Okay.
And Your Honor, would those be commercial trucks or what kinds of trucks? I just want to make sure I'm clear.
Well, this is your limine. So,
Right,
I mean, the opportunity to be clear.
right. So this was
That's
not a
passed.
commercial truck.
But you don't get to rewrite your limine today. Sorry.
Yeah, I know, I understand that, Your Honor, but I just, because they're bringing up trucks, so, and we're talking about fleets, so are we only going to be discussing non-commercial trucks? The number of non-commercial trucks, or are we including everything?
Well, you drafted the limine how you drafted it, and I ruled upon it. And I'm
Yes,
not
Your Honor.
I'm not here to give advisory rulings on things that aren't in front of me. So y'all can confer and see if you can work something out. Okay, number 6.
Your Honor, they indicated that they have 11 videos to play. The court may have noticed that I filed, not only filed our objections that were asserted in those depositions, but I filed the transcript so that the court has those in front of it. I'm asking that that no testimony be played before this jury, before the court hears and rules on the objections as to form and substance, based upon not only the rules of evidence, but the Texas Rules of Civil Procedure.
Okay. I think based on the other motions that you have filed on this topic, I'm going to set number 6 aside because I think we are going to spend some time one way or the other talking about these depot objections. And I think it may have been Mr. Sanders, your motion that said because of the number, or maybe it was the response, the number of objections equals 3 days for pretrial. And I just want to disabuse everyone here of the notion that you would ever get a 3-day pretrial hearing. It's just that is not an efficient use of judicial resources. And obviously, I'm going to implore upon you to please confer on these objections. You know,
I will let the court know.
You can. We'll talk about it Monday.
Yes, Your Honor.
All right, great. Number 7. Oh, wait, did I skip one?
No, Your Honor,
Yeah.
the last one was number 6.
Okay, so number 7.
Judge, given the production in this, I think I'm going to withdraw number 7.
Okay, 7's withdrawn. 8 was
For now.
agreed. All right, number 9 is improper commitment or standard of care during board hire. Oh, that was agreed. All right, so that takes us to 10. Oh, all right, this will be the last one. I see we've reached 10:30. So let's go through this one.
Yes, Your Honor, we're just simply asking that that the court prohibit any suggestion or argument that we have failed or refused to take responsibility for this particular accident. There are, because that's not a standard and it's unduly prejudicial. In this particular case, we have defenses that we have pled. The sole proximate cause, we've pled, we've also pled sudden emergency defense, and we have reasons for denying liability in this particular case. So at any rate, we're asking pursuant to Medina v. Zuniga that they be prohibited from discussing that, because it just has a tendency to inflame the jury, and it's routinely excluded, Judge.
Okay, well, a couple of things. I think the fact that we're having a trial, jury's going to kind of understand that someone hasn't, done something to get the case resolved. That's a little bit different than the way it's worded here, but let me hear from the plaintiffs on this one.
Your Honor, and our argument is just that we're here partially to try the case regarding liability, and we imagine there's going to be about a day of testimony discussing liability of both the defendant driver as well as the defendant company. And like you said earlier, the facts are what the facts are, and that they've denied liability. There are instances in interrogatory responses, depositions, where different stories have been told as far as how this crash may have happened and who may or may not be responsible. As Your Honor, we discussed earlier, they attempted to point the finger at the piece of plastic in the garbage truck that was traveling ahead of our clients. And so there are multiple excuses as to why defendants have alleged they are not liable, but that's why we're here, at least in part, is to try this case on and get a finding on liability. And so the fact that we're here shows that they didn't take responsibility. And so we don't believe that argument should be precluded.
Judge, what I'm specifically asking for is an argument in closing as, which is unfairly prejudicial to, defendants, that says that I've heard before. I'm still waiting. Counsel's been speaking for 30 minutes, and I'm still waiting for them to accept responsibility and say I'm sorry to the plaintiff. And this court is aware that only serves to inflame the jury, and it's unduly prejudicial to the defendant. We have a right to defend ourselves, Judge, and put on the defense. But that's what I'm asking.
Okay, 10's denied. So I think you have enough work to do to keep you busy with conferring on the various items. We will start the remainder of the pretrial Monday at 9 a.m. I think y'all know where I am. We're in courtroom 9D. And we will see you then and there. And unless y'all have any questions, I'm going to let y'all go for now.
Thank you.
Thank you.
Thank you, Your Honor.
Okay, please do confer on those objections. I mean, 11 videos, that's a lot to play. So I hope you have designated the narrowest amount of testimony you need. I'm gonna mull things over as far as your time limits, but I will give those to you on Monday. But right now I'm thinking with the Friday off, we would either close evidence by the end of the day, Monday, maybe argue the following Tuesday. Let me get your reaction on whether you think that's realistic or not.
Going to be really tough, Your Honor.
Why do you say that?
Well, I have 2 plaintiffs who have traumatic brain injuries, and we have multiple experts that we're going to be presenting just brass tacks through deposition video footage. I've taken, I think we've got over 100 hours of video, and I've gotten it down to like between 6 and 7 so far. We've really trimmed the fat, but for both parties to close evidence by end of Monday, I think it would be really rushing it.
All right, Mr. Sanders, what do you think?
Your Honor, with the cross-examination, given the number of videos that are going to be played, I think I agree that it's going to be tough. In terms of live witnesses, I don't have that many. And so depending on how long Mr. Williams is or Mr. Toomey is with cross-examination, I don't have any. I mean, it's a pretty simple wreck, but there are damage issues. I agree. So I think we're going to be hard pressed to get it done, especially if we're missing Friday by Monday.
Well, then I will mull over whether evidence should close on Tuesday. All right, I'll give some thought to that. But I think you know this, that when you ask for 7 days, you know, that is everything from pre-trial through the verdict being returned. And so when I am giving you time and allocating things, I'm also giving the jury, you know, some time to deliberate, especially if they're going to hear 4 or 5, you know, days of evidence, 1 day of pre-trial and voir dire. So we'll see you on Monday.
Judge, one quick question.
Yep.
Depot cuts, because we have so many videos to play. Is it the court's preference? I know there are some courts in Travis County that do not want separate cuts in terms of the direct and then the cross-examination. What is this court's preference as to, do you want them all done at the same time? Do you want them, or do you mind if they're different, each side plays their own?
I don't have a hard and fast rule on this. It would be great if people could play one video and say it includes our designations and theirs. And if your videographer could break down the time for me of, you know, it's 30 minutes for the plaintiff, 25 minutes for the defendant. That's kind of an ideal world, and we don't always get that. So do the best you can, I guess. Is that helpful at all?
Your Honor, we'll be able to tell you down to the second how long each one of our videos is.
Great. And will you be able to break it down? You know, the plaintiff's designations are X minutes and defendants are Y, and play the whole witness?
Well, I haven't cut the defendant's videos for them. I'd be happy to work with them to come up with those numbers. But you know, we want to make the court's job as easy as possible and give clear expectations. But I can tell you, speaking for the plaintiffs, we will be able to tell you the exact amount of time that our videos are going to go.
Okay. Great. Well, hopefully it's something y'all can talk and work through. Whatever solution you think works the best for presenting your evidence. I'm not going to require that it be done one way or the other, because I know it costs money and that's a concern on both sides. So do what you can. We'll see you Monday morning.